Hello, everybody. How are you doing today? We're here, to my MAM subscribers. We're here today back with more on Brendan Dassey. If you've been following my channel, you know that I've been looking into the case law that was originally cited by Brad Schimmel in his opening written brief to the Seventh Circuit Court regarding wrongful confessions and their voluntariness or involuntariness. So I've already gone through all the ones that he cited deeming where the Seventh Circuit Court upheld them as voluntary or deemed the confessions voluntary. If you've gone, you can go back through my videos and see those if you like. I am now on the cases where the Seventh Circuit Court has deemed the confessions involuntary or upheld them as involuntary. And this is the second one of the two that Brad Schimmel cited in his brief. This one is AM versus Butler. This involved an 11-year-old kid, and it's pretty kind of horrific what they supposedly think that this kid did. I'm not saying that it's impossible, but it's pretty horrific. They're essentially, the crime was, whoever it was perpetrated by, was basically beating this old woman, this 90-year-old woman, with her own cane, slitting her throat, and emptying her purse out onto the kitchen floor, essentially. And then in this document that I'm getting this information from, it doesn't say whether there was money missing or anything. It doesn't really get into the facts of the case, really, because really the Seventh Circuit and the appeal courts aren't interested in fact finding. If they don't disagree with basically the original court's fact finding, they never question it. So you really kind of don't get a whole lot of personal facts regarding these cases, but which is a shame. If we knew these cases more intimately, like we kind of know the Stephen Avery case, because we've been looking into it, we might see some funny things in these cases too. And I think in this one we would. I think this one has the earmarks of something rather strange going on. There's also the fact of, and you'll see it referenced here in some of the documents I'm going to show you. There's a reference to the fact that the state, the representative for the state, the lawyer for the state, Miss Hoffman, she failed to present the review or the decision or even the opinion of the district court judge who granted habeas relief to AM. So because she did not include that, it's like a big no-no with the court. And she ends up getting fined $1,000. You could tell they are very peeved by it. We'll see mention of that in there, but that's like kind of one of the things that kind of made me go like, what? Why is she not involved? Why is she not including things? Is that some kind of a game? But it's weird because you also see that the state of Illinois, like the way that they pressed this issue with this kid, this 11-year-old kid. It's like, what was going on behind the scenes here? It's just odd. It's hard to, seriously hard to believe an 11-year-old child could do such a thing, such a brutal act. Like I said, not saying it's impossible, but then when you get into the facts of this case where the kid says, well, yeah, but they were saying that I should confess and that God would forgive me, and if I did, I could be home in time for my brother's birthday party. Now the cops in the case claim that never happened. So you get these earmarks of something a little bit under the table going on, even though you don't get to look into all the facts of the case, but just looking at some of the things that are getting looked at on appeal, you can kind of go, ooh, yeah, there might be something there to look at if you had all the case info. But anyways, so we'll move into the first document here where it essentially kind of explains the crime itself and who AM is. It doesn't really refer to his name fully. It just says AM or Morgan. That's because they're trying to retain some anonymity for the guy. He's not a kid anymore, obviously. Anyway, so you won't really see his name. It's just AM. Anyways, we'll go into that first document now, and then we'll come on back. So here we see in the top paragraph what the state could have lost because they didn't include the appellate record of the case. This whole entire appeal could have been dismissed because of it. They chose not to do that. But anyways, finally, before leaving our pre-merit concerns, we note another error in the state's principal brief, plus an argument that is much ado about nothing. First, on page 4 of its main brief, when referring to the Illinois Appellate Court decision, the one not included in any appendix, the state says it is a published decision. That is wrong. The decision is not published. It is not retrievable on any electronic database, nor is it printed in any book. Second, the state complains that the district court improperly conducted an evidentiary hearing on Morgan's petition, yet the state fails to point to any material use of the information elicited at that hearing. Rather, the district court ultimately accepted the historical facts found by the Illinois Appellate Court, and so where is the harm caused by the federal hearing? Because none is cited, we dismiss the state's objection on this point and now move on to the merits of this appeal. Morgan lived with his mother, Janet Timms, next door to the house where the elderly Miss Gilvis lived, apparently alone. On October 5th of 1993, she was found dead in her home, the victim of a terrible crime. She had been beaten with her own cane, her throat slit, and tied with a phone cord, blood all over the place, and her purse emptied out on the kitchen floor. Okay, so now we're going to move into this documents that basically where they're talking about, number one, the first one, they're going to be talking about really a lot of the similarities, I think, that really occur between AM and Brendan's case. Mainly, the fact that neither of them had any previous contact with law enforcement. No interviews, nothing really. No charges, no history, no juvenile stuff. I mean, both of them had zero contact with law enforcement previously. And they go on to talk about that here, how that's a factor because it's really hard for somebody, in a kid particularly. They even talk about a kid under 17 in these documents, you'll see. It's hard for a kid under 17 who has had absolutely zero contact with law enforcement, just isn't accustomed to this situation, that they just don't realize that they can leave at any moment if they haven't been told they're under arrest. If the cops are acting like the cops want them there, need them there, they got to talk to them. They don't always understand their rights. They don't understand that certain things need to be said, otherwise they can walk out. They're kids. They don't know, and if they've had no contact with law enforcement, they certainly don't know. I mean, that's just common sense. So they talk about that here, and then they go into the argument about, whether or not Am was actually taken into custody, and the thing is that the information that he offered, they feel should have been suppressed. When they were bringing him in as a witness, but then when they brought him back for the interrogation, because of the way they did that all wrong. Because Am admitted to it, then he denied it. He was telling his mom, "I didn't do it. I just said that." You get the, like I said, we don't get all the facts, but you get the impression here that there was some kind of maybe head games going on, because Am keeps kind of flip-flopping back and forth. Anyways, they come and pick him up again from his house. They get permission. They say they're just picking him up as a witness, and that his aunt, I believe it is, that he's living with, doesn't need to come down there with them. And they bring him down to the station, put him in a room for 2 hours, and interrogate him. And the claims are that they were pounding on his knees. They told him that if he just confessed, that God would forgive him and that he could be home in time for his brother's birthday party. But of course, the cops deny that this ever happened. So, I mean, there's just a lot of what really happened here. There's one point where they criticized the Illinois state court method of determining the confession voluntary, because they were basically not following Supreme Court precedent and what's gone before. they relied basically almost entirely on the memory and thoughts of Detective Cassidy and his recollections and stuff like that, instead of looking at the things that they should have. So that it's funny how you'll see that in these documents in this video too. So we'll move into the first set of documents here right now, and then we'll come on back. With Morgan's age in mind, we turn to the circumstances of the case and note that Morgan was not a seasoned juvenile delinquent. In fact, he had no prior experience with the criminal justice system when he was questioned for 2 hours in a closed interrogation room with no parent, guardian, lawyer, or anyone at his side. Since the police told his mother it was unnecessary for her to come to the station, he was at the mercy of detectives to be driven home. Thus, he had no way of leaving the police station, even if he felt he could leave. Nor was he ever told that he was free to go, nor that he was under arrest. Furthermore, compare this encounter with the police to his prior two, where he sat in a police car outside of his own home and then at a desk in a public area of the police station, all while the police were nice to him. Finally, there were significant concerns regarding the mode of questioning. Morgan insisted that the detectives leaned closely towards him when they spoke, promising him that both God and the police would forgive him for what he did, and asserting that if he told the truth, he could go home for his brother's birthday party. Cassidy denied these activities, but acknowledged that he was close enough to Morgan he was close enough to touch Morgan, and that he repeatedly told Morgan that he was lying. All these facts lead to the conclusion that a reasonable person in Morgan's situation would have considered his freedom curtailed. See E.G. Alvarado, a 17-year-old subjected to a 2-hour interrogation. A 17-year-old, by the way. It is simply unreasonable to conclude that a reasonable 17-year-old with no prior history of arrest or police interviews would have felt that he was at liberty to terminate the interrogation and leave. California versus Baylor. No custody found, but the suspect was told that he was not under arrest and allowed to leave whenever he wanted, and left 30 minutes after the interview. In Oregon versus Mathiasen, where a suspect was told immediately that he was not under arrest, and the interview only lasted 30 minutes. The Illinois Appellate Court's decision to the contrary was, we believe, an objectively unreasonable application of federal law. We next turn to the Illinois Court's decision that Morgan was not under arrest for Fourth Amendment purposes when he made his statements. If a statement is obtained through exploitation of some illegal arrest, it must be suppressed. Brown versus Illinois. Dunaway versus New York. An unlawful arrest occurs when a person is seized by police without probable cause. Whether a person has been seized is determined by considering whether a reasonable person, innocent of a crime, would have concluded that he was free to leave police custody. Michigan versus Chesternut. We agree with the district court that the Illinois court's resolution of whether Morgan was seized was contrary in established Supreme Court precedent. A decision is contrary to established precedents in the court, confronts the set of facts that are materially indistinguishable from a decision of the Supreme Court, and nevertheless arrives at a result different from the Supreme Court precedent. In a case identical to this case, the Supreme Court wrote, the detention of petitioner was in important respects indistinguishable from a traditional arrest. Petitioner was not questioned briefly where he was found. Instead, he was taken from a neighbor's home to a police car, transported to a police station, and placed in an interrogation room. He was never informed, and he was that he was free to go. Indeed, he would have been physically restrained if he had refused to accompany the officers or had tried to escape their custody. All right, so now we'll talk about this next set of documents, which is they go into the determining of the custody. The Seventh Circuit Court had an issue with the Illinois State Court's method of determining custody because they didn't like it, because it depended in great deal upon Detective Cassidy's subjective beliefs, and they didn't like that. So the other thing about the custody is that, in determining, whether or not it was reasonable, whether AM knew he could leave, that he wasn't under arrest. Well, he was dependent on law enforcement or, officers or detectives for a ride home, because they picked him up from home and told his aunt, I believe it is, that she didn't need to come. So that leaves him there effectively stranded. At 11 years old, he can't even walk home at 11 years old legally. So there's really no way he could have left had he gotten the notion. So that's one thing that the court points out. They don't like it. So then they move on to having an issue with the determining of whether or not he was able to waive his Fifth Amendment right. They go into that quite a bit. They determine that up to this point that the appellate court and the Illinois State Court, that they're determining that his Fifth Amendment right, his ability to waive his Fifth Amendment right was not in question. They don't agree. The Seventh Circuit Court didn't agree. They felt that it was an unreasonable application of Supreme Court law. So that's one thing we'll see coming up here. And then it goes into a segment where you see the Seventh Circuit Court getting on the state about the fact that they left out it wasn't the district court, the district judge and the district court's ruling and stuff. It was actually the appellate court's information and stuff that was left out. But you see the Seventh Circuit Court now addressing that. You can tell that they are very angry about it because they keep talking about it. They keep bringing it up. And in this time, this is when they talk about the $1,000 fine on Miss Hoffman, and they give her 14 days to come up with basically a reason why she couldn't provide that in the time that she was supposed to have provided it. So if she doesn't come up with some good reason in 14 days, is basically what this is saying, she would have to pay the $1,000 fine. So you just wonder why that got left out. And then you look at all the things in this case that just seem a little strange. The way that they, went off of this Detective Cassidy's subjective beliefs. The way that this one, they left out the appellate court's, record of the case. The fact that the detectives, they deny that they ever said the things that AM says that they said. God will forgive you if you confess, and you can be home in time for your brother's birthday party. Those types of statements, and the pounding on his knees. So I don't know. There's a lot of room to wonder here. So anyways, we'll go ahead and move into those last set of documents here, and then we'll come back briefly. The Illinois State Court's finding that Morgan was not under arrest was objectively unreasonable. In making its determination, the Illinois State Court, citing People v. Matthews, correctly acknowledged that courts rely on the same factors in determining whether a person is in custody. The court again, however, based its decision on Detective Cassidy's subjective beliefs. It wrote, "The evidence of Morgan interrogation prior to the confession indicates that he was considered a witness only. The focus of the police investigation had been on an adult suspect. The court did not mentioned that Morgan was alone, his age, his prior inexperience with the criminal justice system, or the fact that the interrogation took place in a closed police room, nor did it acknowledge that Morgan was dependent on police for transportation home, and Cassidy testified that he would not have let Morgan go. And while Morgan was never told that he was free to leave, he also was never told that he was free to leave. He was also never told he was free to leave. All these factors lead to only one conclusion. On the basis of the record, Morgan was, for all practice and purposes, under arrest within the meaning of the Fourth Amendment when he made his inculpatory statements. Finally, the state court's decision regarding whether Morgan's confession and the waiver of his Fifth Amendment right to remain silent was voluntary was objectively unreasonable. A voluntary relinquishment of the right occurs when a waiver is a product of a free and deliberate choice, free of intimidation, coercion, and deception. Moraine versus Burbine. In evaluating voluntariness, we are required to examine the totality of circumstances. Fair versus Michael. We recognize that under AEDPA, we must give deference to the state court's judgment. However, as the Supreme Court has noted, even the context of federal habeas deference does not imply abandonment or abdication of judicial review. Deference does not, by definition, preclude relief. Miller versus Cockrell. This case exemplifies that principle. Here, where the only evidence tying Morgan to Gilvis's murder was the statement given under highly questionable circumstances, the filing of a suppression motion by his counsel would not have been, as the Illinois court said, a futile act. Now, that's where I think he had a little bit in common with Brendan right there, because the only thing linking Morgan to this crime is the confession, which is looking very shady. So, finally, we return to Circuit Rule 30, back to the leaving out of the appellate court's decision. Returns to Circuit Rule 30, we noted earlier in opinion. We have repeatedly emphasized the importance of compliance with Circuit Rule 30 in United States versus Rogers. We said, compliance with Circuit Rule 30 is essential to proper performance of the appellate task, especially by the members of this court, whose chambers are outside Chicago and who lack instant access to the record. Even judges with chambers in Chicago often prepare for oral argument at home or elsewhere and need the district judge's reasons ready at hand. As the Supreme Court has said, a juvenile in police custody needs the aid of more mature judgment as to what steps he should take in his predicament. An adult relative could have given the juvenile the protection which his own maturity could not give him. Gallegos versus Colorado. Of course, the Supreme Court has never required per se the presence of an adult. See Michael C. Versus, U.S. Okay. But it is, however, a significant factor considering the totality of circumstances. In fact, in the marginal cases where it appears that the officer or the agent attempted to take advantage of the suspect's youth or mental shortcomings, lack of parental or legal advice could tip the scale in the favor of involuntary confession. There is no reason to believe that this 11-year-old could understand an inherently abstract concept, the inherently abstract concepts of Miranda rights and what it means to waive them. Juveniles' capacity to waive Miranda rights and emphasized analysis. 96% of 14-year-olds lack the adequate understanding of the consequences of waiving their rights. Moreover, psychological studies argue that juveniles are highly susceptible to an adult suggestion. Journalists have also recently reported on children's susceptibility to adult suggestion during interrogations. So at the end of that segment of documents there, you saw where they mentioned the fact that not having a friendly adult present is a big factor when things kind of end up coming out evenly in the AEDPA's the guideline for determining voluntariness and involuntariness of a confession includes age, intelligence, background, various things. And they're talking about that, and they're talking about the fact that when a lot of those things weigh out evenly kind of against each other or whatever, the tipping point factor tends to be the fact that if the juvenile didn't have a friendly adult present, that tips it in the favor of making the confession involuntary. So it brings that up here, so I thought I would say that. And then, because that's also, I think, similar with Brendan. And then it also brings up there at the end how juveniles are highly suggestible, right? I mean, I've made a video before about Brendan where I posted the psychiatric evaluation that had been done on him, and it says the same thing exactly. And then it says that particularly with Brendan, he is even more suggestible than the ordinary 16-year-old. So I mean, there's clearly something there. So I think it's interesting that these cases do seem to have so many similarities, and that Brad Schimmel himself put this in his brief as a example of an involuntary confession, because in a lot of ways it really does mirror Brendan's. Now this kid's 11, but this kid, seems like he was trying, maybe playing games or whatever. I'm not sure. I know for certain that one of the judges, it was a 2-1 decision on this. One of the judges basically still believed he did it, and he couldn't believe the other 2 judges were going to rule the confession involuntary. But another funny thing about this case is that this case was argued by Stephen Drizzen. I thought that was very interesting. You guys can go down into the info, of course, as normal. Go down in the info. I'll have the link, so you can go read this document for yourself or whatever. But basically, right in the first sentence, you see that Stephen Drizzen is the counsel arguing for AM for his side. So, basically, that's about it for the reviewing the case law for in Brad Schimmel's original written brief to the 7th Circuit Court. This is the case that Laura Nyrider pointed to in her written brief that came after Schimmel's. Basically pointing out, it's funny that Brad Schimmel brought that case up, because that case actually has more similarities to Brendan's than any of the other cases he brought up. So anyway, I thought that was great. Anyways, that's about it for this video. If you haven't already, please hit subscribe, and we'll see you guys again soon.